SJC-11552, Commonwealth v. Muniur M, a juvenile.
Let's proceed.
Good morning, Your Honors. I'm Lois Martin, and I'm here on behalf of the juvenile. I would ask for 2 minutes of rebuttal time saved. Your Honors, the appeals court was incorrect in its statement that there's nothing in the evaluation that supports the claim that the father forced my client to make a plea. Admittedly, there's no words that says, my father is forcing me, but there's clearly information in this document that reflects it. It shows that it reflects his behavior. It shows an observation by the evaluator of what my client was feeling at the time when he was evaluated. This was the pre-sentencing. He had already made the plea. And this report was going to reflect on his sentencing. In the report, it says, when in with his father, he is very withdrawn, stating staring at the window and answering questions in barely audible, short responses. However, when alone, he became more animate and responsive. That is an actual observation. That's not something that someone can interpret differently than an actual observation. You can't fake it. This young man was 14 years old at the time. He was, at the sentencing, he had just turned 15, like 2 weeks before.
So 18 years later, he brings this. 18 years, essentially making it impossible to try the case. When did he realize when did he realize that this was not voluntary?
I think he realized it right from the start, Your Honor. In the affidavit, he said he was angry. He was, in the affidavit that he provided to the court, his words were, at the time of the incident, he says, I did not want to do this, but he gave me no option. I felt pressure to resolve my case so it would not impact my father's case. I remember being really scared, not of the courts or the police, but of my father. I mean, he's 14 years old, let's be honest. Even at that, if you want to consider him a teenager, boys are more immature than girls. He was intimidated, and he could not proceed without his father's signing the document. You know, you have to have a parental signer. So he says that his father's at war, and he felt like that he had let his father down.
Would your position be that in order to find his admission to sufficient facts acceptable, that he would have had to appear to be relaxed and calm in the presence of his father?
No, I'm not saying that, but I'm saying that the appeals court is saying that there was nothing to show that he felt forced, and I'm suggesting that that language does. I would also go on to say that it shows the evaluator herself reflects that the father had an obsession about what was going on, that even when he came to make the appointment, in the third paragraph it says he began immediately, as he had done when he came to make his appointment, by explaining to the examiner about the Pittsfield police had it out for him due to a well-publicized lawsuit that he had brought. In other words, it was all about him. Even on the time when he made the appointment, it was always about him. Further on the report, it says that the mother indicated that she struggles with the same scenario at home, that getting her husband to focus on family issues versus his lawsuit. Now, obviously, it's not just the affidavits that we presented. We presented about 10 or 11 news articles from the newspapers of what was going on at that time, plus the First Circuit decision, which clearly reflects an entire history of onerous behavior by the Pittsfield town solicitor, if no one else.
Does the record reflect why this is coming forward 18 years later?
Well, my client, after this occurred, and this was his first case, except for a first case that had been resolved. He had been arraigned 3 weeks before he was charged on this case. He had no other prior court experience. He then, unfortunately, developed quite a record and was in and out of jail and state prison even. He developed a drug problem, which he no longer has anymore, and has changed his way, as the record, I believe, reflects. But his father's case, even though it appeared that it had settled, did not settle, and it was not resolved until finally in 2004, which is, quite a distance from 1992, 1991, when he initiated his case. After that, there was like a couple of months, and my client was in prison again, unfortunately. I heard from him in the beginning of, I can't remember the month, but in 2009, when he was in prison with another client of mine who had a similar charge, not the same case situation, but a similar charge, and he contacted me. I then contacted the committee, so that it sort of took a while to get things going. But yes, there was a period of time. But I don't know exactly when he confronted his father. He told me that part of it had to do with when he was at one time when he was in prison, and they had group therapy, and they discussed this and how you must come to terms with certain things. And at some point, one of those prison sentences is when he started thinking about it, and at some point he finally confronted his father. I don't know the specific timeline, but that is really the time sequence. And I would just point out that this court has said time should not matter. It's justice. Justice was not done. And even on the Barron case, that was over 25 years, or the Petabello case, which was, I think, 50 years. The goal is, the time should not be the issue, and I'm not so sure that this could not be retried.
Given the unusual facts here, why is not the better course to send it back for an evidentiary hearing?
Well, I agree with you, Your Honor. If the court, the appeals court said on the record they did not, and based on their decision, I filed instantly a petition for rehearing, asking, in the alternative, asking them to send it back for an evidentiary hearing. They have often done that on other cases, but they denied my petition for rehearing, and I have no idea why they chose not to send this back and chose other cases. I tried to figure it out, and I was not able to. I think, each panel is different, and I could not figure out why they did not do that if they felt that was, they thought that would help. And, I would ask that this court, I would just say the appeals court did not really take into consideration, they said that the judge did not, they interpreted it in one paragraph, and the motion judge, interpreted it another paragraph, and I think looked over the entire situation. They seemed to be somewhat dismissive of her, that they didn't show that where she had actually abused her discretion or where she had implied the law incorrectly. They just said they disagree with her interpretation, and I would suggest that that was not sufficient, that
That they should have given some deference, in other words.
Yes, exactly. Otherwise, the courts are going to be enormously jammed up with these types of cases.
Ms. Martin, now you have to stop now, and you'll be back in a few minutes.
Thank you.
Good morning again, Your Honors. Joseph Puropan for the Commonwealth. May my argument please this court. To answer Judge Gantz's suggestion of whether or not a solution may be to order an evidentiary hearing, the Commonwealth would respectfully say that would serve no purpose, because the motion judge already found that the affidavits filed in support of the motion for a new trial did not hold water. And yet she then continued to rely upon the aid in sentencing report to somehow bolster the claim that the defendant, juvenile, was coerced into pleading guilty. So there was no request for an evidentiary hearing below. It was
Wait, I'm sorry. You're saying that the judge below said, I'm going to order a new trial, even though I don't credit the testimony of the juvenile that I was pressured, and don't credit the affidavit of the father that I pressured him.
there's no testimony. They're both affidavits, Your Honor.
Both affidavits,
Yes,
right?
she-
But
she-
they don't
she
credit.
absolutely
They don't
said that.
credit those affidavits.
Said
You're
the
saying,
affidavits don't hold water. It was in her oral findings.
all right. But I mean, if you look to see what the judge did as opposed to what the judge said, the judge did order a new trial.
She did order a new trial, and I would submit that would be an abuse of her discretion in order to do so, because the report, as the appeals court pointed out, did not include any information that would in any way corroborate the affidavits filed by the defendant and his father some 19 years after the fact of the conviction. The point here is that this appears to be one scenario in which after the defendant, I'm sorry, I'm confusing defendant and juvenile, I apologize, in which the juvenile has found himself to be classified as a sexual offender, or a sex offender, rather, and it was forced to register pursuant to the 2000 law, and was classified as such, that he found that that was a consequence that he did not foresee. And I would ask the court to consider the chronology here. It is absolutely clear that at the time that the juvenile was charged, his father was embroiled in a most unfortunate, I would say ugly, battle with the city officials. In 2004, the First Circuit basically exonerated the father, and in fact disbarred the city solicitor temporarily. That's 2004. Now, I have 2 points to raise about this. If in fact the defendant, I'm sorry, the juvenile was following his father's lead and saying, you're going to make matters worse for me by going to trial, number one, that is not logical. Why it strains credulity to believe that if an individual were to admit being a rapist, rather than face going to trial, why would he toss his father's enemies the card of, look, your son's a rapist and you're a bad cop? That strains credulity. I'm sorry, did I interrupt, Justice?
Well, I don't think it strains credulity. There's a lot of publicity about a trial that may not be about a plea, and so it's out there more.
It's a juvenile session. There'd be no publicity at all.
Yeah.
Be no publicity at all. And that's why I suggest that it does not make sense to simply plead guilty. If there was a trial, it'd be held in a secret session.
Closed session.
The Commonwealth's recommendation on a plea was for a straight probation. Arguably, the consequences would not have been that severe. The defendant, I'm sorry, the juvenile was not indicted or proceeded against by way of a transfer hearing or as a youthful offender. So from the get-go, the Commonwealth's dispositional option was on the low end. But more importantly, going back to the chronology, once the First Circuit in 2004 exonerated the defendant's father, found the city at fault, at that point in time, why didn't the juvenile come forward and say, and you know what, I felt coerced. I didn't say anything until now because it would have reflected poorly against my father. That's all said and done. Waits 7 years, or at least till 2011 to file the affidavit. Only then has he been classified as a sex offender. These facts look very much like the Barrios facts, in which Mr. Barrios, who at the time of his offense was 14, he was proceeded against by way of being a youthful offender. He was convicted, subsequently convicted of a second armed robbery, and then he became an armed career criminal upon an adult conviction. He then challenged his juvenile convictions based upon the fact that he claimed his lawyer and his brother coerced him into pleading guilty, rather than spend to a recommendation for less than a lifetime in jail. I think that these facts that we have before the court are very much similar to that, in that we've already had a finding by the motion judge that the affidavits themselves are not as credible as they would appear to be.
So where's that in the
Where's
record?
that finding?
Yeah, where's that in the record?
I'm having a hard time finding it.
Yeah,
So
If I may-
I'm in
if
the
I may,
same
Your
boat
Honor.
as Justice Cordy.
I apologize for not having that on the tip of my tongue.
I see where she finds that the 15E report corroborates the affidavits.
Yes.
But I don't see where she finds the affidavits not credible. I'm having trouble with that, frankly.
Pardon me, Your Honors. Findings, page 15.
Excuse me?
But where in the record?
There apparently, there are 2 volumes in the 3 volumes.
Okay, yeah, we just have the
Page,
appendix.
But we have the transcript.
Transcript
her
of the hearing.
Oral findings.
Yeah, but, oh, you mean not in here? Because the transcript in here doesn't have that. There's a transcript in here, for sure.
no, there's not.
Well,
No,
there's a transcript in here where she says, I conclude that the 15E report corroborates the affidavits.
that's on page 7 of the findings, Mr. Justice Cordy. On page 15, she indicates the affidavits alone don't hold water, but the 15E backs them up. That's the findings of the judge.
I'm sorry, tell me again where that is.
Page 15 of the findings.
And the findings are where in the record? I have her oral findings here.
There's a separate record somewhere.
Apparently, Ms. Murray has handed to me what is being referred to as the 3rd section of the motion hearing findings dated May 31st, 2011. At the top of page 15, it says, on the affidavits alone, they don't hold water.
I'm not sure we
And then she
have
goes on
that,
to say what?
actually.
I'm sorry, she goes on to say,
Yes, it goes on to say, but with the 15E backing it up contemporaneously, absolutely.
oh, so
He was coerced, it was
does
not
that merely
involuntary.
simply say that if this were all I had, I wouldn't credit it, but given that it's corroborated, I find it credible?
What the judge is saying is that she finds the affidavits alone not to be credible. She further finds in the 15E evaluation some information, some evidence to corroborate the affidavits. The Commonwealth's point is that the 15E evaluation does not say that. And this court, in its review, can take a de novo review of this because the plea judge has since retired. Motion judge was not the plea judge. Appeals court did de novo review. This court likewise can do de novo review and examine the 15E report to show that, on the contrary, it shows that the family is appropriately concerned about their son's plight. There's no indication that the son is being overborne by his father's will. If anything, the father predominates the conversations, which is why when the son and the father are together in the room, the father is doing all the talking and the son is withdrawn. With the father out of the room, the son is more animated and verbal. This is not inconsistent with a finding that he was not coerced. So it'd be the Commonwealth's point that there would be no need for a testimonial hearing because the judge has already found, based upon the affidavits, certain weight to the affidavits, little weight, certain weight to the 15E, great weight.
So is it your view that an appellate court should not defer in any respect to a trial judge's findings with regard to the affidavits?
She wasn't the trial judge, Your Honor.
Or, I'm sorry, the motion judge's findings?
No, because the motion judge was not the trial judge.
I know, but okay, so the motion judge, the judge who actually had the matter before her. No deference at all to her assessment of the
because
credibility.
her findings were done based entirely upon the affidavits and the 15-year report, and the pleadings.
Completely de novo,
the pleadings.
our judgment versus
Yes.
her judgment.
Your judgment, you're in as good a position as the motion judge to review the pleadings, which is upon which this case was decided. And
Thank you, counsel.
Thank you very much for your time, Your Honors.
Now, Ms. Martin.
First of all, Your Honor, I believe that Mr. Pierpont was referring to the Berrios case, and Mr. Berrios was an adult and had a criminal record. There's a major difference, as this court has reflected in recent decisions, between a person that's an adult and a child. With regard to the father, I would just point out that in the forensic service report, it says, certainly there is, in the middle of the third paragraph, there is some denial on the part of both parents, but especially the father, on the seriousness of the charges against their child. And in his affidavit, he points out that I was told, I forced my son to plead guilty to the charge against his will. He did not want to do it. In fact, I did not want to plead him guilty to the charge, but Judge Barbalunga, who has retired, convinced me to force him to plead guilty. I was told the case would be sealed and not to worry about it, that the conviction wouldn't affect him as an adult. The judge spoke with me at length to convince me to get my son to plead guilty. So the father, even with his obsession, at least tried in some fashion, but nevertheless, I think that this report was, this forensic service 15E evaluation was essential to helping the court to come to her conclusion, and I believe that I would ask that you support her conclusion. She says that, at the end, she says that the line of communication seems to be breaking down in this family, both between children and parents and between the parents themselves. The parents saying that we want what's best for our child. Any parent would say that. These people were in a compromised position, and obviously they were going to say things that they thought would be accepted. I would just say additionally that the time thing, I would suggest, should not be the major issue on this case. The issue, again, is that the appeals court, I would suggest, misinterpreted what occurred in the motion session findings and chose a section that I think does not really support what actually this evaluation does support. And I would ask that you reverse their decision and reinstate the motion judge's decision allowing my motion to vacate guilty plea. Thank you.
Thank you, counsel.
All right.